You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Thanks for joining us for Let's Get Surety. During today's podcast, I have my co-host, Mark McCallum, CEO of NASBP. Hey, Mark.
Great to be here, Kat.
And we're going to be talking a little bit about the new wage theft laws that have been going into effect and what they mean for contractors, subcontractors, and some contract bonds. And to discuss that with us, we have another Mark. We have Mark Berry, and he's a partner at Peckar Abramson. Thanks for joining us, Mark.
Oh, thank you for the invitation. Looking forward to today's discussion.
Great. Can you before we kick into the topic, tell us a little bit about yourself and Peckar Abramson?
So Peckar Abramson is the leading construction law firm in the United States and perhaps internationally. We have upwards to 100 attorneys that focus on construction. So it's our bread and butter. It's what we do every day. I am a partner in the Washington, D.C. office of Peckar Abramson. I focus both locally in the D.C., Maryland, Virginia markets and nationally and internationally. So, we are dealing with, on a regular basis, assisting our contractors in issues that arise, including, the current developments in the wage theft laws.
So to dive in, I think it's important to understand what these wage theft laws are. Can you kind of give us the gist of maybe the new law that just went into effect in Virginia on July 1st?
So the law that went into effect in Virginia is a replicant of the other wage theft laws that have been passed in the various states beginning about 5 or 6 years ago. The Virginia's has slightly less teeth than some of the more stringent laws, but there has been a trend, particularly in the blue states, to hold general contractors responsible for lower tier subs and suppliers who are not meeting their payment obligations of their employees. As it is in the industry, it is those lower tier subs that sort of operate on the periphery of the wage requirements. They're the ones most likely to not abide by minimum wage laws, overtime laws, prevailing wage laws, and the problem that the industry realized was that it's considered unfair that the general contractors are getting, funding from the owners, sometimes public owners, and they get the full benefit of payment, and it's not making it down to the workers who are performing the work. So again, particularly in the blue states, there were laws enacted that said, we want to make sure we want to have structures in place where employees who aren't getting paid properly have recourse. And since the subcontractors simply may not have the financial stability, the financial existence to satisfy any unpaid wages, they're allowing those employees to go directly against the general contractors. That serves two purposes. The first purpose is that unpaid employee can recover his wages, his or her wages, against the general contractor. And it also has the effect that the general contractors, knowing that they are liable for those unpaid subs or sub-subs all the way down the line, they're going to be more diligent in ensuring that these lower tier subs are fulfilling their payment obligations. So the intent is really twofold: get the workers paid, but probably in a broader sense, to get the general contractors involved in ensuring that they are paid in the first instance, and you're not making unpaid workers have to sort of chase and file lawsuits to recover their wages.
Well, Mark, certainly wage theft is probably not new. I find it kind of interesting that construction seems to be more in the sights of legislators and others about this. You seem to kind of hinted at, why, but why now, I guess, would be my first question. And then, is it really fair? I mean, is the general contractor really able to make sure that the pay procedures are proper at 2 and 3 and 4 tiers down?
Well, we'll take those one at a time. Why now? Wage theft has been around for a long time. There has been, I think, growth in certain areas of the infractions. One is the classification of exempt workers. If you're an employer and you have a managerial employee, you do not have to pay them overtime. But if you are a non-managerial employee, you do have to pay overtime. And in the construction industry, the laborers doing the work are non-managerial employees, and they're entitled to get paid time and a half for hours that they work over 8 hours. Those laws were vigorously enforced, beginning, I don't know, in the last 10 years or so, and or the imposition of the overtime requirements. And so employers who, again, are interested in maximizing their profits, looking for a way to do that, would misclassify employees so they don't have to pay them overtime. And that is the growth area, I think, in the violation is the misclassification of overtime employees. The other issue that's sort of arising at the same time, unscrupulous subcontractors often will identify employees as independent contractors because they can avoid having to pay taxes, workers' comp and worker comp fees. And that was sort of a big driving factor because the worker comp rates would be very high. And if you take and it's based on your employee count. So if you count your employees as independent contractors, you lower your workers' comp rate. So there's certain sort of aspects to this that, it's been around a while, but it was realized that there was a real effort by, again, the unscrupulous actors to take advantage and to avoid those requirements. And I'm sorry, what was your second question?
So the second question is, it seems like it puts the general contractor in a very difficult position, essentially being the guarantor of proper payment procedures all the way down the line. Kind of what's your view on that? And do you think that's fair? And whether that even matters? And then maybe how should general contractors look at that in states that have these kinds of laws?
So, I think the perception is as you go down the chain, it's not fair to the general contractor to police a lower tier subcontractor. You just don't have the visibility at that level. I mean, you can request it. You can have it flow down through your subcontracts and have your subcontractors require their subcontractors to provide adequate records and proof of payment. But I think the perception is that it is a bit of a task to ever believe that a general contractor can fairly police it. Now, what it can do, though, is change the behavior of the general contractor. So what they do is they become, it sort of drives you to select your preferred and trusted subcontractors. And if you're, in turn, making your subcontractors responsible for those obligations, they, in turn, will choose and select their preferred and trusted subcontractors. It adds a little bit of illiquidity to the subcontract market.
Right.
And it probably drives the prices up because your most trusted ones are going to be the ones that are probably not going to be the least expensive. But again, it maybe recognizes a reality that those cheapest subs and sub-subs out there were probably cheap for a reason, because they were the ones most likely to flout the laws. So, on a micro level, a general contractor really can't control what's happening downstream. On the macro level, it changes behavior across the tiers and across the industry, and you just have to be more diligent about who you're hiring. So, whether that's fair or not, I think generally it kind of processes through and leads to a sort of a balanced result.
Mark, that's really interesting, because I'm wondering what kind of impact this will have then on small and disadvantaged subcontractors. How do you see that playing out in jurisdictions that have these kinds of laws?
Well, I mean, that could be certainly be an unintended consequence. That there is real reluctance to hire growing, unknown, disadvantaged contractors who you don't have a track record with. You may be adverse to hiring them or having your subs hire them, because there's a risk there that you wouldn't face if you hired someone you've worked with 10 times previously and their track record.
Right.
So I mean, that's a real consequence that I think is real.
So, it sounds like also that sometimes violations might not be deliberate. They might be inadvertent if somebody's less sophisticated. Would you like to expand upon that?
Yeah. So, and this is important to note. And you mentioned the new Virginia statute that went into effect July 1st. Some of the statutes, the minority of the wage theft statutes, have a good faith exception in the statute that says the general contractor is not liable for the subs payment if they were acting in good faith and didn't have knowledge or reason to know that the non-payment of wages was occurring. That is a milder version of the statute. So if you're the GC and you didn't have somebody essentially blowing a whistle or providing you records that would, very apparently demonstrate to you that the wages weren't properly being paid, the general contractor can escape liability. And so that is, there is some efforts in some states to recognize that, hey, if there are violations going on that were not intentional and were not blatant, that they're not going to hold the general contractors responsible. Now, in Maryland and DC, there's no such exception. And again, it's probably less fair, but more likely to change behavior if the general contractor doesn't have basically the legal excuse that we didn't know about this, and so we shouldn't be held responsible.
Right.
So you mentioned that you just mentioned Maryland and DC or other jurisdictions that have similar types of legislation. Are there many other jurisdictions? How widespread is this type of legislation?
So it's growing every year. I mean, DC was one of the first. But so the list is, and it tracks the blue states. It's Colorado, California, New Jersey, Minnesota, DC, Maryland, Virginia, Illinois. Just had one that went into effect this year. And so it's a small number of states, but it's gaining momentum, I believe. And there is it's almost there's a sort of wage theft project where advocates for labor are going around state by state and lobbying the legislatures to enact these statutes, and so as they get more wins, you can expect they sort of learn how to do it, and you're going to see efforts to expand it to other states.
Wow. So if you're a contractor in one of these states now that has these laws in place, I think you had mentioned that they're changing their behaviors. And it sounds like pre-qualification is going to be even more important, that contractor conduct really good qualifications. What are some of the other behaviors that you're seeing by contractors to mitigate their risks?
So the Maryland and DC and Virginia statute have a provision that says, as a general contractor, if you have to pay some wages, the wages of a subcontractor's employee or a subcontractor's employee down the tiers, then you can you can recover that through a statutory indemnity against your subcontractor. So, if the subs didn't pay their employee, the general contractor ends up having to pay those wages. You can recover it against your subcontractor through a statutory indemnity. Of course, that's only that indemnity is only as strong as the financial viability of your subcontractor. The other issue is all three statutes say the statutory indemnity will be replaced by a contractual indemnity if the parties have a contractual indemnity in their contract. And and almost always with a general contractor has indemnity provisions in their subcontract. So a general contractor needs to, this is a sort of a absolute requirement. You've got to go back and look at your indemnity provision and make sure it specifically covers obligations for wage theft, because the worst circumstance you can have is have a statutory indemnity right as a general contractor, but then you've replaced it with a contractual indemnity right, but your contractual indemnity right has less teeth than the statutory one. And then you've worsened your position. So you've got to review your contractual indemnity provisions to make sure you're specifically dealing with the wage theft obligations. And if you really want to enhance it, you should consider, and it will be resisted, but you should consider having the principals of the contractor with whom you are subcontracting, the subcontractor's principals, have them sign off personally on the indemnity. Because again, if you're dealing with a subcontractor who may be thinly capitalized or an LLC, you don't have a recourse against them. But if you have a personal guarantee, the owners of those companies, then suddenly they become much more responsive to concerns and suddenly can find money to pay in the obligation that the general contractor had to pay.
It sounds like you need to have knowledgeable counsel up front, making sure that you're connecting all the dots and making sure that you have the right scope and all that. Are you seeing more contractors go out and be proactive, employing good legal counsel to make sure that they are reviewing their contracts and subcontracts properly?
Yeah. We do, and that's the reaction when to these wage theft laws, because you can read them, you can understand the obligations. General contractors understand the obligation that they are not only responsible for the unpaid wages, but they can be responsible in Maryland for double penalties. So you not only have to pay the wages, but you have to pay up to an additional 2 times the wages. In DC, it's 3 times. So there's quadruple recovery. And so with that type of risk and exposure out there, we're getting calls from contractors that say, hey, look, 2 things. Can you review my contracts to make sure I'm protected? And number two, what can I do administratively in administrating these contracts to protect myself along the way? Because, the best contract only goes so far if your procedures fall down on the project. And so we provide that. We have sort of advice during project administration as to what you can do to minimize your risk.
Are attorneys' fees part of the equation as well?
They are, but they are for the unpaid laborers, and so and it's basically because if you're a individual employee and you've been shorted $500 or $1,000, it means a lot to you as the employee, but it doesn't give you much to bring an action to recover if you've got to pay a lawyer. So
right.
all these, it's universal across all the wage theft statutes. That not only does the employee get to recover the wages, they can recover penalty wages, right, 2 or 3 times. So it gives them an incentive to report, and they all have attorney's fees provision. And so what that means is 2 things: the worker's recovery is not reduced by the cost of hiring an attorney, but it also creates a market of attorneys out there who are advertising and looking for laborers who said, "Hey, look, if you haven't been paid properly, I'll fight this fight for you because they will be reimbursed by the by the general contractor in a successful if they get a successful recovery."
Right. Wow. Yeah. So a lot of incentives to do what's needed and be proactive. Mark, are you seeing general contractors requiring more subcontract bonds as a direct or indirect result of these laws?
So we are seeing it in some instances. And it really is part of it is the risk tolerance and the cost associated with that. Obviously, for general contract, if they feel they can bear the cost of the bond, and certainly if it won't disqualify them from a bid situation by increasing their price greatly, they'll purchase the bond for protection. But if it's a public contract where it's a hard bid world, they're less likely to do that because they know that puts them at a pricing disadvantage.
Wow. So in terms of what advice you would give any contractor who now is in a jurisdiction or has decided to pursue work in a jurisdiction with these laws, are there certain key points you'd like to get across?
Yes. And one is that you really do have to monitor the payroll activities to the best that you can of your subcontractors and require those subcontractors to do the same for their lower tier contracting parties and forward that information to you. It's not simply enough to say except in Virginia, in DC, Maryland, it's not simply enough to say, well, I had no reason to know my subs employees or sub-subs employees were getting paid, that you have an affirmative duty to investigate. And so you really have to, with those monthly payment applications that are coming in from your subs, you have to require them to show payroll records, include it with your payout. And you need to have that documentation, and you need to assign one of your employees to review them.
Well, those are great points, Mark. Thanks so much for joining us today and sharing that information on the wage theft laws that are out there right now. If anyone wants to get more information from Mark's firm, which is Peckar Abramson, you can check out their website at pecklaw.com. Thanks so much for joining us.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.